Good morning. We're just going to give it a minute for people to join. Good morning and welcome to the 31st installation of the Panitch Training Academy. Today we'll be discussing patent litigation damages. My name is John D. Simmons. I'm an intellectual property litigation attorney, although I also counsel many clients on patent prosecution, trademarks, and copyrights. I was a professional engineer in the electrical engineering field for years before becoming a registered patent attorney, so I focus on tech and the mechanical and electrical arts. My colleagues, Dr. Jeffrey W. Gluck and Stephen E. Murray, will also be presenting today, so I will pass it to them. Dr. Gluck, would you please introduce yourself?
Hi, I'm Jeff Gluck. I've had multiple careers. I have a bachelor's in electrical engineering, computer science, a master's in electrical and computer engineering, and a Ph.D. in electrical engineering. I've worked in industry. I've been a professor, and then I switched over to patent law. My practice today comprises primarily patent prosecution. I have been involved in litigation as well, both on trial teams and in appellate litigation. I am involved in the standards world in terms of being active in groups having to do with standards, in terms of assisting clients in determining the issue in terms of dealing with issues relating to litigation and licensing of standard essential patents. And I, in fact, have written parts of the equivalence of standards. Let me pass it over to you now, Steve.
Thanks, Jeff. As I mentioned, my name is Stephen Murray. I have a bachelor's degree in physics, and then I went straight to law school after undergraduate and have been practicing with the firm for close to almost 20 years now. My particular focus is in the semiconductor, optical, and electrical fields. I do both prosecution and litigation, but I do have a special practice at the Patent Trial and Appeal Board for inter partes reviews and post-grant review processes. Back to John.
Thank you. Before we begin, I can give you some webinar tips. This webinar and our other webinars are recorded and can be found on our website to view at any time, on demand. If you have any questions, please drop them into the chat or the Q&A, and we will be checking those areas to answer any questions as the webinar progresses. If you are seeking CLE credits in PA, Delaware, Georgia, or Virginia, please ensure to answer the 2 pop-up polls that come up during the session and take the feedback survey at the end of the webinar. We'll remind you about the pop-up polls. All right, now let's get started. So today we're going to cover patent damages in general, reasonable royalties, lost profits, price erosion, standard essential patents or SEPs, and briefly expert discovery. Patent infringement damages are generally outlined in 35 U.S.C. Section 284. It essentially says you're entitled to at least a reasonable royalty from someone who uses your patented invention. But the courts have held that you are entitled to damages that make you whole in terms of harm, which is where lost profits and price erosion come into play. If damages are not found by a jury, a court can still award them. The court can also hear from an expert to aid in the determination of damages, which we will talk about at the end of the session. Calculating patent damages is very complicated. Under 35 U.S.C. Section 286, you can, depending on notice or patent marking, recover damages back 6 years. So what triggers that 6-year period? There's actual notice and constructive notice. Actual notice is when you send a letter to the accused notifying them of the patent or patent application publication and identifying an accused product. Constructive notice, on the other hand, is given by marking your product covered by the patent with the patent number. You can also use what's called virtual marking. Virtual marking is where you list a website address on the product, and on the website you can list the patent or patents that cover the product. The benefit to virtual marking is you can update the website as you get additional patents, or when patents lapse or expire, you can take them down. As an aside, you can also give notice of patent application publications. You cannot sue over a patent application publication, but once the patent grants, after you're given this notice, you may be able to collect a reasonable royalty back to when you gave notice of the publication. The caveat to this one is the claims have to grant with substantially the same claims. Mr. Murray is going to discuss reasonable royalties.
All right, thanks, John. So if you think about the language that we discussed from Section 284 just a minute ago, it says the court shall award damages in no event less than a reasonable royalty. And that means a patent owner is entitled to a reasonable royalty at a minimum as a result of a finding of infringement. So you can conceivably get more, but you can't get less. So obviously how you get to a reasonable royalty becomes highly critical, because as a patent owner, you're going to want to drive that number as high as you can. And as an infringer, you want that number to be as low as possible. Now, interestingly, you could advance a position on what a reasonable royalty rate should be, and the court can completely disagree with you. But the court can't then say, well, you failed to prove it, so you get nothing. The statute is clear. You are entitled as a patent owner to something. So this means even if both parties are way off base with their numbers, the court still has to find something that the evidence in the record will support. The only way you could get zero is if there's absolutely no evidence in the record that could be used to determine an award, which is a rare instance. And when we get to the Georgia Pacific factors, you'll see how hard it might be to have nothing in the record whatsoever. Now, I do note that this is different from lost profits, which John is going to talk about later. As a patent owner, if you go for lost profits and fail, the court can then say, okay, no lost profits for you. It's different for reasonable royalties. There isn't one way to determine or calculate a reasonable royalty. The courts are open to various different methods of getting there, with certain exceptions which are notably excluded by the precedent. But if you came here today hoping to learn the bright line rule for how to figure out a reasonable royalty, you are unfortunately going to be disappointed. As it says on this slide 5, royalties can be awarded in different forms. You could have a running rate, like a percentage of sales, or you could have a lump sum. Often you see a lump sum that is awarded to compensate for past infringement, with a running rate that goes forward on any post-trial sales. Although sometimes a total sum might be ordered that acts as a paid-up license for all past and future infringement of the patent. It's a flexible process. If you could go to the next slide, please. All right, now I said there was no bright line rule for calculating a reasonable royalty, but one of the most accepted methods comes from an old Federal Circuit case, which is Georgia Pacific. And that case listed out a number of factors that you can consider when trying to figure out the royalty. I want to go through them with some examples so you can see how these factors influence or can influence the thinking on whether the royalty should be higher or lower, as a way just to see how the courts treat the evidence. These factors are considered in the context of what's called a hypothetical negotiation between the parties. So assume the parties came together before the case and negotiated a rate. What would they arrive at? And these factors get to what happens in that negotiation. So the first one you have is patent owner royalties from licensing the patent. This is a straightforward factor. If the patent owner already has licenses out for the patent, that's pretty instructive as to what the parties would have agreed to in a hypothetical negotiation. If you have a bunch of licenses at 2%, maybe the reasonable royalty ought to be around that figure. Things get more complicated though if, for example, the patent owner's licenses cover multiple patents, and now you have to determine what fraction of that rate is attributable to the patented issue. But having an actual license involving the patent is very good evidence for a reasonable royalty. The next factor is related. Are there licenses for other patents out there that are similar to the patented issue? How much are improvements to vehicle windshield wipers usually worth? So you look for other windshield wiper patents and find those licenses and see what those rates are. This definitely gets harder the further away you are getting from the actual invention. And even in the example I just gave, you could argue, well, my patent on windshield wipers is more valuable. So this factor is less encouraging than the first one, but when you can find something similar, that can also be a good guide for the ballpark you should be in. Factor 3 examines what is this hypothetical agreement going to look like? Are we talking about an exclusive license or a non-exclusive license? A licensee is likely to pay more for an exclusive license because you're getting a better deal. Are there geographical restrictions in this license? Are there restrictions on who the accused product can be sold to? So sometimes you get field of use licenses. You can only sell this product into the automotive industry, but you have to stay out of aerospace. Those kinds of restrictions might bring your royalty rate down. You'll pay more as an infringer if there are fewer limitations on your license. Next one, the patent owner policy on maintaining a monopoly is sort of the inverse of the first factor. So as a patent owner, just say I refuse to give out licenses. I want to exclude others. And so I have a strict policy that if someone is asking me for a license, I tell them no. And that obviously doesn't work for damages in a court case. So how does this factor into the hypothetical negotiation? Well, if I don't like licensing, but I'm now in a situation where I have to, that's going to raise the amount as a patent owner of what I consider as a reasonable royalty because I am losing the exclusivity that I'm trying to maintain. But on the other hand, if you're out there giving away licenses like free candy, this factor is not going to do much for you. The next one, the relationship of the parties. This is a big one. If the infringer is a major competitor of yours, you're going to want more in the hypothetical negotiation because now they're getting your patented technology to compete directly against you. There should be a premium for that. The farther away the parties are from each other in the market, the less this will influence the royalty because you as the patent owner now, you're not going to care as much about their access to the invention. Next factor is the effect on other sales. Does your patented invention raise the floor? Let's go back to the windshield wiper example. If my patented windshield wipers make it more likely you're going to buy a car, and I realize that's a ridiculous example, but that's a common one for this, so please bear with me. If that's the case, it's significant. But if I, as an infringer, would see that I could sell other things as a result of getting the ability to sell the patented thing, I'm also going to pay more on a royalty. So if I see, hey, if I can sell the patented windshield wipers, I can now also sell the higher quality windshield wiper fluid. That's going to benefit me as the infringer, and I might be willing to pay a higher royalty for that. The next factor on here is how long does the patent have left? How long is this license going to last? The longer the patent has to go before it expires, the more valuable it's going to become. If there's only a year left in the hypothetical negotiation, the competitor now has the leverage to say, well, I could just wait this out a year and then bring the product to market. So that's going to decrease the possibility of the royalty. But if they have to wait longer because the patent has more life to it, now they may be more willing to pay so they can break into the market earlier than they would have otherwise. Profitability is kind of a no-brainer. The more profitable a product is, the more likely someone would be willing to pay a higher royalty on it because there's more money to spread around. If I'm on a razor-thin margin, I need to hold on to as much of that profit as I can, or it's not worthwhile. Now, there are cases where the royalty actually was more than the profit, but you have to remember these are factors that get weighed. These Georgia-Pacific factors, they're not hard and fast rules, but typically a higher profit margin means a higher royalty. Next slide, please. All right, factor 9, this is like how much of an innovation is this invention really? If we're talking about a minor improvement over what existed before, how much are you really going to pay to get that benefit? If this is the greatest thing since sliced bread, yeah, you're going to pay more for that. This is one of the factors where your damages expert is probably going to have to consult with your technical expert to get a handle on how much better is this thing, because that's going to impact the value. And you might have heard about, are there non-infringing alternatives to the invention? That can go to this factor. The fewer options you have to do what the invention does without infringing will raise the royalty rate. The next factor looks at how the patent owner is selling the invention. Is it just a piece of a larger machine, or is it the key to sales or functionality? Is it driving customer demand? Obviously, the more important the invention is, the more it's going to be worth. The next factor is very similar, but you're looking at it from the infringer side now. What has the infringer done with the invention so far? And this is where the hypothetical negotiation really gets the benefit of hindsight, because normally at the stage of negotiating a real license, you're guessing at sales, you're guessing at how something is going to perform before you take the license. This factor is basically like, knowing now how well you did selling this thing, would you pay a royalty of X? Factors 12 and 13 interplay with each other. This is about what's the typical profit you're going to get in this field and how much of your profit is actually coming from the patented invention. If you're seeing $100 worth of profit ordinarily in comparable products and you're making $100 selling a patented device, that implies you're just riding the typical sales wave, and that bodes poorly as a patent owner for getting a higher royalty rate. But if you're way outselling the normal profit ratio, now a higher royalty rate becomes more supportable. And then the last two factors here, the qualified expert testimony and the hypothetical agreed royalty, there's debate in some circles about whether they are actually subsumed within all of the other factors that I've been discussing with Georgia-Pacific, or if they are in fact separate factors and you see courts treat them differently depending on the circumstances. But generally, as you'll find out towards the end of the program, you definitely want qualified expert testimony because this is complicated stuff. And then the hypothetical agreed royalty is supposed to take in all these other factors into account. Next slide, please, John. All right, well, now that's all well and good if I'm selling you a dingus and nothing but the dingus, but real life tends to be more complicated than that. So we're going to go back again to the windshield wiper example. If I have a patent on just a windshield wiper, you're probably going to arrive at some percentage royalty, but what's the base that that royalty gets applied to? What's the number that you multiply that percentage to get your royalty rate? You're probably not going to use the $50,000 MSRP of the vehicle to multiply by the royalty rate, unless the rate is super tiny to reflect that combination, or if under some strange circumstance, the windshield wiper really contributes to the overall value of the car, which again, I highly doubt. This Erickson case from the Federal Circuit you see on slide 8 explains that if you have a multi-component feature, you will typically have a combination of royalty base and royalty rate that reflects the value attributable to the infringing features of the product. The court says we don't want to mislead a jury by placing an undue emphasis on the value of the entire product if the infringing feature really is not imbuing the other features of the combination with value. So windshield wipers don't tend to add too much to the car. The car is probably more about the engine and other interior guts that drive it rather than just something to keep off the rain. So in most instances, you're not going to get to use the $50,000 price tag as your base. And the same logic applies to profits as well. If you can't show the wiper has a significant impact on the overall profit that the seller gets for the car, you won't be able to use that either. That's the concept of apportionment. You need to get down to what's the reasonable contribution of the invention to the overall, and then work from there.
I have a question. And we also have the poll number 1 up. So we'll get to the question after the poll.
Yes, please make sure you fill in the poll because you need that to get CLE credit to prove that you were here. So Jeff, why don't you throw that question?
Yeah. If the question is, if the law allows for triple damages, does that include reasonable royalties, lost profit, and price erosion?
So of that, the
Wolfland is going to be based upon whatever the damages were awarded. So it'll be a multiplier by whatever damages were awarded. Normally, you're not going to get all three. You would either get a reasonable royalty, you get lost profits, and price erosion.
Right. Yeah, I didn't quite understand the question. If the question is about treble damages and willful infringement, yeah, you're right. You're multiplying whatever your final damages number is by whatever the court deems appropriate. If the question is, do you get all three? As John said, you don't. You usually will get reasonable royalty or lost profits, and price erosion can factor in with the lost profit side of it. But if you get the reasonable royalty, typically you won't get anything else. The law doesn't typically allow for overlapping damages. Can we go to slide 9, please?
Indeed.
All right, so I hedged back on slide 8 because I'm a lawyer, but I said you're probably not going to get that full product price as your royalty base, but that is sometimes available, actually. We have what's called the entire market value rule, which allows you to use this entire market value of the product as your base, but the patented feature has to be the sole driver for consumers in buying the overall product. As I mentioned earlier, the engine is probably one of the most important features of the car, but I would venture that people buy cars for a lot of other reasons than just the engine. So unless you've invented a revolutionary engine and everyone is buying your car because of it, and not because it also has bucket seats, you're probably not going to invoke this rule. The patented feature could be important. It could be essential to operation of the product. But unless it is the sole reason that people are buying, the entire market value rule is not going to apply. And so, as you can imagine, this doesn't get invoked a whole heck of a lot, although it's not for a lack of trying. And I do have one correction. I said the Georgia Pacific was a Federal Circuit case is actually incorrect. It was a Southern District of New York case that came about long before the Federal Circuit ever existed, but has since been adopted by the Federal Circuit and courts for determining reasonable royalties. So with that, I turn it back to John, I believe, to cover lost profits.
Thanks, Steve. So reasonable royalties that Steve just covered are the floor, but the holy grail in patent damages are lost profits. To recover lost profit damages, the patent holder or exclusive licensee must show a reasonable probability that but for the infringement, the patent holder or exclusive licensee would have made the sales that were made by the infringer. The seminal case on lost profits is Right-Height versus Kelly. In Right-Height, the defendant produced vehicle restraints for trucks on loading docks, similar to those produced by the plaintiff. The Court of Appeals for the Federal Circuit held that where the lost profits of the patent holder were reasonably foreseeable, key phrase there, reasonably foreseeable, lost profits were compensable. The two products were almost identical and directly competed, so the court found that the plaintiff would have made the sale but for the infringement. So it's a but for infringement test. The burden to prove lost profits is on the patent holder. The patent holder must paint on the board gross revenues. The burden is on the accused to demonstrate costs. And the key here, so you're going to subtract gross revenues, costs from gross revenues. But not all costs need to be applied. Fixed costs like rent or salaries may possibly be excluded if the patent holder makes multiple products or services. Only those incremental costs, like the cost of goods, shipping, and returns, will be applied. So the patent holder gets the profits it would have made on the sale, but for the infringement. The question is, had the infringer not infringed, would the patent holder or exclusive licensee with a right to sue made the sale? It's the but-for infringement test, if I say it over and again. There are factors the courts consider to determine lost profits, if it's entitled to lost profits. Demand of the patented product, the important absence of acceptable non-infringing substitutes or non-infringing alternatives, the manufacturing and marketing capability of the patent holder or the exclusive licensee with the right to sue, and the amount of profit the patent holder would have made on the lost sale. The manufacturing capability of the patent holder considers whether the patent holder could have actually filled the orders for the lost sales. If they can't, they're not going to be entitled to lost profits. The main defense, or the most common defense to a claim for lost profits, is the absence of non-infringing alternatives or non-infringing substitutes, as we say. So basically, is there a design around that could have replaced this product? The patent holder need only show that there was a reasonable probability that the sale would have been made but for the infringement. So they don't have to go to the nth degree to show that they would have made the sale. The patent holders and accused infringers' products must be sufficiently similar to compete against each other in the same market segment. In other words, the products have to be truly competitive in order for the case to qualify for lost profits damages. We'll take this BIC case as an example. In BIC, the products at issue were windsurfing boards. The court found that the price points of the windsurfing board, it's hard to say, were significantly higher than BIC's, and therefore windsurfing did not show with a reasonable probability that BIC's customers would have purchased from windsurfing in proportion with windsurfing's market share. Thus, the but-for test was not met. So because windsurfing's boards were so much more expensive and BIC's products competed at a much lower price point, they found that they weren't competitive. The court noted to be acceptable to the infringer's customers in an elastic market, the alleged alternative must not have a disparately higher price or possess characteristics significantly different from the patented product. So if the two products don't really compete, you're not going to get lost profits. Lost profits really kick in when you are direct competitors with substantially similar products. Only a patent holder and exclusive licensee with the right to sue can have standing to bring an infringement suit. We're going to take Spine Solutions as an example. Spine Solutions was the assignee of the patents in suit, but there was no dispute that Spine Solutions did not make or sell anything. It was just a holding company. So Synthase, the parent of Spine Solutions, put all its patents into Spine Solutions for tax purposes. That was a problem. So in order to attempt to get lost profits, Spine Solutions moved to amend its complaint to add its licensee, its parent and its affiliate, Synthese Spine and Synthese. The court found that there was no evidence of an exclusive license. So basically, Synthese didn't have standing. Therefore, Spine Solutions couldn't get lost profits. But they could always get the reasonable royalty, as Steve said. Lost profits are almost always more significant than a reasonable royalty, which is why it is the holy grail of patent damages. The takeaway for your client is that damages can be significantly higher if the patent holder sells the actual product covered by the patent. So these holding companies for tax purposes could cost a lot of money, as Synthese found out.
So is the strategy then, if you're going to, for tax purposes, have a holding company for the patent, the license back to the company that's actually making the product should always be exclusive?
Exclusive with a right to sue, and it should have been in writing. Synthese basically said that they had a company policy that there was a license, but they didn't have a writing. So yeah, Steve, it's a really good point. Okay, the corollary is that non-exclusive licensees do not have standing to bring a patent infringement suit, as Steve politely pointing out. In Spine Solutions, I mentioned, there was no written license agreement, so there was no exclusive license with the right to sue found. A little side note on lost profits. There's also convoyed sales. This is kind of an esoteric concept. It's very rare. Convoyed sales capture damages on non-patented goods that are functionally associated with the sale of the patented product. Functionally associated is the key phrase. And this is very rare, hard to get. But there's one famous case, Juicy Whip. In Juicy Whip, they got damages on the non-patented juice concentrate that went along with the juice dispensing machine, the patented juice dispensing machine. The court found that the non-patented juice concentrate was functionally associated with the patented juice dispensing machine, and therefore Juicy Whip could collect damages on the juice concentrate too. Very rare. There's also the concept of price erosion that goes along with lost profits. Price erosion occurs when the patent holder or the exclusive licensee has to lower its prices due to the infringement. In other words, because the accused infringement occurred, you have to lower your prices and you should be compensated for that loss. Price erosion damages are also very hard to prove and very rare. Again, it's a but-for infringement test. But for the infringement, the patent holder would not have had to lower its prices. Now I'll pass it to Dr. Gluck to talk about standard essential patents.
Okay. Well, given the time constraints, obviously, I'm going to try and give an overview of damages in the arena of standards essential patents. There are many details that go into this, but and with that being said, why don't we get started? Standards essential patents, or SEPs. They are exactly what they sound like. They are patents that are required for the practice of an established standard. Whether this is in well, the ones I'm most familiar with are in the electrical area. Things like telecommunications standards for mobile telephony, video streaming standards, digital broadcasting standards, and things like that. Okay, so basically the way it works with a standard is that there is a standard is created by a standard setting organization, or SSO. And that's generally with contributions from people who or organizations who wish to be involved, typically large companies. Now, there are two categories of standards essential patents. When an SSO establishes a patent, a standard, a patentee may register their patents that they assert to be essential to the standard with the SSO. By doing that, they're contractually obligated to what's called a FRAND licensing or royalty rate. And what FRAND stands for is fair, reasonable, and non-discriminatory. Now, there's some uncertainty as to exactly what FRAND is, and we'll talk a little bit about that later. Now, Most of my discussion here will be related to what happens when the patentee actually registers and declares their patent or or patents to be essential to the standard. But there are every so often you will come up with someone who doesn't, or some individual or company that does not declare their patent to be essential to a standard. In these cases, FRAND rates are not contractually required, although courts may, in determining damages or royalties or licensing rates, they may take this may take this into account. They may take the FRAND into account, but essentially, damages and royalties for an undeclared patent that is determined to be essential to a standard are at the discretion of the court. Next slide, please.
Jeff, we have a question. Does FRAND mean that the royalty needs to be the same, or the royalties could still be different based on the margins of the final product manufacturing company?
What FRAND means, that's actually one of the things I was going to mention. I was going to address, but I'll address it right now. FRAND is a kind of a loosey-goosey kind of term. It's kind of like the it kind of relates. It's kind of like the Georgia Pacific factors when determining royalties. There are many there are many considerations, and between two particular parties, there may be different considerations than between two other parties. Although, so the courts in various jurisdictions, including here in the United States, have determined that that FRAND does not necessarily mean that the royalty rate between two initial parties will be the same. But I'm sorry, let me put it a different way. The royalty rate set for one infringer will be the same as the royalty rate set for another infringer. If they and that, of course, that it makes it into court, and that the parties don't work it out between themselves, which is really the goal of the FRAND commitment, is that the parties are theoretically supposed to engage in negotiations between themselves and determine what's fair, reasonable, and reasonable. And by the way, the non-discriminatory part is that the patent owner is required not to prevent someone who wants to take a license to take a license. In other words, the patent owner, if someone approaches them for a license, they are required to make a good faith effort to offer a license to that party.
Jeff, do they also have to give like most favored nation rates?
That's interesting. Well, typically the royalty rates will not vary very much between licensees. That being said, there is wiggle room because there's no requirement for the licensor, that is the patent owner, to disclose to the licensee what the patent owner has given previous licensees. So So again, the whole idea of the FRAND commitment is to avoid getting into court. But what happened, it's to encourage license patent owners to offer licensing opportunities and to encourage implementers to enter into good faith negotiations with the patent owners. So given this framework, when do SEPs get into court? The SEPs typically get into court when there are disputes over whether there is good faith observance of FRAND terms by both parties. Okay, so that can be when a potential licensee doesn't believe that the licensor, that is the patent owner, is offering them is making good faith effort to negotiate terms. The same thing on the other side, where the patent owner believes that they're making a good faith effort to offer to negotiate a reasonable royalty, but the licensee does not, the licensee doesn't accept it and makes no effort or little effort to negotiate. This basically it's when the two parties involved in the negotiation reach a roadblock that in the negotiation process, or there's refusal to negotiate altogether. As I was saying before, just for completeness, if it's an undeclared standard essential patent, FRAND terms are not required. So it's a normal patent infringement matter, normal negotiation matter between the patent owner and a potential licensee. FRAND does not govern. Next slide, please. Okay, so for declared patents, so how do we determine the royalties or damages if we're in court? I'm not even going to talk about non-declared patents. Let's just concentrate on declared patents. And in the United States, this is we always begin with the Georgia-Pacific factors, which Mr. Murray discussed earlier. But some of the ones that are some of the factors that most often come up in the SEP world are agreements with other licensees, and the value of the standard essential patent relative to the particular product. And this is a big one because I'll use a more standard-oriented approach than Steve's windshield wiper example. Let's look at it. One of the things I like to look at is your mobile phone. In this mobile phone, there are thousands of patents. There are literally thousands of patented innovations in the standards involved in a mobile phone implementation. and they're owned by all different parties. So how do you, what are some of the approaches that have been taken in determining how much to apportion to a given patent owner? Now, one of the things is if you have thousands of patents, and say your mobile phone costs $1,000. Well, if everyone wants every patent owner wants $1 per patent, no one's going to implement the implementer is going to go elsewhere. They're going to do something different. It's going to turn into a total chaos, which by the way, is simply not going to happen. Because the whole purpose of a standard is to create compatibility. It's so your mobile phone will be compatible with all of the service providers, be able to access the different communication networks, and be able to implement the different features required in order to do that. If there's one thing you take away from this, it should be an understanding of what a standard is, which is basically a compatibility document or a compatibility set of documents. So some of the approaches or arguments, and we mentioned these a little bit earlier, is looking at related licensing agreements for the standard essential patent. And another approach, which has been argued a lot in the standards essential patent arena, has been determining damages or royalties as a percentage of the value of a product. Now, there are two approaches here, and I'm going to say these are also part of the Georgia-Pacific factors, but I'm going to couch them slightly differently. One is called the top-down approach, which is that you attempt to estimate the value of the standard, the SEP contribution, as a percentage of the total product value. So that's, say, taking your suppose you have your patent is related to a display feature. Oh, well, no, that's a bad example. Say it's related to a channel access feature. How much is that worth in terms of the value of the entire product? And again, in the United States, this mirrors the Georgia-Pacific factors. The other one, and the bottom-up approach, which is in contrast, is an attempt to estimate the value of a SEP contribution to a smallest saleable unit, or SSU, implementing the standard essential patent. So, for example, a chip that implements different protocols required by the standard may incorporate, again, hundreds of patents or more. And how do you apportion value among and suppose the chip costs 50 cents. How much is that? How much is that patent worth to the in terms of the price of the chip? So these are actually competing approaches. The patent owner will often start from the top-down approach in their arguments, and the implementer may start with the bottom-up approach, and somewhere the court has to or the negotiation has to end up in in making some balancing between these approaches. And we have poll number 2 up. So everyone who needs CLE credit, please fill out, check a circle.
And Jeff, while we're breaking for the poll briefly, we have another question, which is, as a defendant, is it possible to force a non-declared patent into the FRAND regime?
No, the declaring a patent is voluntary. So you can't force a patent owner to declare their patent. But what you can do is say that you can say, for example, if the patent owner, and this very, very rarely happens, but I'll say it just for completeness, if the patent owner happened to have been involved in this in the creation of the standard with the SSO, and they didn't declare that patent, the defendant can accuse them of bad faith and maintain that they are required to comply with FRAND terms. But again, you can't force someone to accept FRAND under normal circumstances. Although a court may still apply FRAND terms when determining a royalty rate and damages. So, okay, next slide, please. Okay, so another within this whole framework is the importance of the standard essential patent features to the overall value of the product. And again, Steve spoke about this earlier. So I think I will just skip this slide in order to avoid repetition. But an example here of a minor feature having low importance might be an operating mode, one operating mode out of a number of operating nodes that need not all be implemented in order to comply with the standard. In other words, there may be optional features, and your patent may only be relevant to one of those options. So, okay, next slide. Okay, before John steps in, I just want to mention two things that have entered into very quickly, two things that have entered into the SEP arena. One is is courts in one country setting worldwide licensing royalty rates. This was first done by a court in the United Kingdom in the Unwired Planet versus Huawei case. The main thing there is the parties have to agree that they agree to accept that court's determination of worldwide licensing rates. Another issue that has arisen in the framework is anti-suit injunctions, which relates to the international aspect of this, which is where a party will seek an injunction in one country against the other party, so that to try and keep them from filing lawsuits in other countries and accepting the judgment of the court in the country in which the litigation has already occurred. Okay, so I've added the international aspect of this. John, I'll turn it over to you for expert discovery now.
Okay, very briefly. As you can tell from all the discussion we had so far, damages in patent litigation is very complicated. And So generally, you're always going to want to have a damages expert in a patent litigation. I can't think of an instance where we haven't used a damages expert in litigation. Generally, the expert discovery comes after fact discovery. So you have fact discovery where you're getting all your documents and your interrogatories and taking depositions of fact witnesses and corporate representatives. And then after that comes the period of expert discovery. Steve and I have a case right now, though, where the judge wants expert discovery to happen in parallel with fact discovery. And it's a very aggressive schedule, pretty rare in a patent case, but he's a very eager judge. Normally, you do fact discovery, then expert discovery comes. But it's usually best to get your damages expert early on so you can get assistance with crafting your discovery requests and your deposition questions. So the expert may tell you, hey, you know, it would be great is if you could get the overall financials of the company so I can tell the overall profitability to see what if the profitability of the accused device actually checks out. And they can give you questions to ask the corporate representative. You know, what are your costs? What are your fixed costs? What are your incremental costs? What are your costs of goods? What's your cost of shipping? What are your cost of returns, etc. With a damages expert, you want a really experienced testifying expert who has never been Dalberted before. Dalbert, for those of you who don't do litigation, was a famous case where it's a motion to disqualify the expert or portions of his or her expert report. So when you're interviewing the expert, you want to find out if they've ever been disqualified before. Damages are difficult to calculate. In fact, there used to be, for reasonable royalty, a rule of thumb rule called the 25% rule, where you take 25% of the profitability. The Federal Circuit got rid of that. So now it's a matter of the expert going to databases of comparables, just like shopping for a house. Finding licenses in the industry, which are not always easy to find because settlements and licenses are often confidential. So you want an expert who is well versed in the law and precedent and has testified numerous times. Any questions?
I don't see anything new in the chat.
I've got one for Jeff, just in case. I take it the value some companies see in not declaring their patents for an SEP is the possibility of getting higher infringement damages. Is that why somebody would not declare a patent for an SEP?
That is typically, well, there are two reasons. One is if the company or individual has no voice in setting the standard, and the standard happens to incorporate their what they've claimed in their patent. I refer to that as the hit the jackpot situation, because they just happen to walk into a situation in which they can get royalty. The other thing is, the other reason is that yes, they are trying to. They don't want to take part in the FRAND regime, and this really, if I can give an editorial my own opinion about this, this is undermining the entire regime of having standards, and because in order to, if you hold out your patent and prevent others from even knowing about it, and then come back and sue them over that patent, or aggressively pursue royalties, and which may often end up in court. It's like it's like throwing a sucker punch. It's like not doing something without warning, and it undermines the regime, in that the whole idea of setting standards is so that everyone will be on the same page, everyone will know what's going on, and you won't have situations like that.
Well, I think our time is up. We really appreciate you attending. And if you have any questions, you can see our email addresses on the screen. And thank you for attending.
Yes, thank you.
Thank you.